Dear listeners, on this episode of our AI special, we are joined by Professor Noam Shemtov. He's a renowned expert in IP and technology law, and we had the pleasure of discussing with him the evolving role of patents and copyright in an AI driven world, as well as the ongoing debate about ownership of AI generated works and the transformative potential of quantum computing. Noam also shared his unique perspective on the future of IP law and why it's essential to adopt a holistic approach. And here's some exciting news. We actually managed to convince Noam to come back with us next Thursday, the 16th of January, for an exclusive webinar called Inventorship and AI Defining the Human Role in Patent Law. You will find the link to register in the description below. This episode is packed with insights for anyone curious about the crossroads of technology and law. So let's dive in.
Hello, this is IP Stories by 4IP Council, a podcast about innovation and intellectual property. Join us and you'll hear about the journeys through invention, creation, and IP understanding of our guests. I'm Fernanda.
And I'm Marta. And we have with us today Professor Noam Shemtov, Professor of Intellectual Property and Technology Law and Director of Queen Mary Intellectual Property Research Institute. Noam, welcome to IP Stories.
Thank you, and it's a pleasure to be here, Marta, Fernanda. Looking forward to it.
Yeah, we were also really looking forward to having this chat with you. So, to start, we've been doing some research and we realized that you have such a fascinating career where there is academia, legal practice, and working with global organizations as well. What drew you to intellectual property and technology law in the first place? And how has that journey shaped the way you see the field today?
Oh well, I think since I remember myself, I was also always intrigued by technology way before I became a lawyer. So first as a consumer, child, teenager, and then after becoming a lawyer and continuing to be an avid consumer of technology in various forms and contexts. I started to develop the understanding regarding the significance of regulating technology and the impact that it may have if done properly. So when that happened, my journey to IP and tech on the intersection between intellectual property and technology was natural. I think that my specific journey also as first as a practitioner, then to academia, helped me to develop my perspective that IP, I know it may sound as a given, but IP as a tool, it means that, again, that's my personal perspective, that IP is a means to an end and not an end in itself. And therefore, a balance should be struck, the right balance between the expectations of the various stakeholders and, how would I put it, maximalism, therefore, should be avoided. It's not, at least in my view, it shouldn't be an ideology. It's a tool in order to achieve various objectives.
So, you're qualified as a solicitor in both the UK and Israel, and you've worked with organizations from all over the world. How has that international experience influenced the way you approach IP law?
Oh, thank you. That's an interesting question. I think that we don't. I believe we don't work in the context of IP in a domestic vacuum or isolation. Innovation crosses borders, and therefore, an approach, a solution, a fix, in a national sense, should be of course sensible, but should also fit within the international context. So when you come up, say, with an approach that, for the sake of an example, that completely departs from an international standard, or what is acceptable between major actors out there, you take a risk, and I think a big risk. It's not to say that the risk is always a bad thing. So when that happens, you can either, under certain circumstances, drive away some activities and functions from your jurisdiction, which you would not like to do, or perhaps when it is a successful move, under certain circumstances, the opposite will happen, and you should be able to draw into your jurisdiction some activities that you see to be of benefit. Now, there are various examples, and they're out there, and there are some, and I guess the jury is still out, so to speak, whether and to what extent IP IP played a major role in such instances. So, for example, the US approach for patenting software, so a very favorable approach towards a number of decades in the very late 20th century and early 21st century. To what extent that played a role in the US becoming a center, or probably the leading force in that particular field. I also think that we should be, and I'm a bit digressing here, we should also be humble enough as lawyers, IP lawyer, to acknowledge that IP is only one instrument in a toolkit of a jurisdiction that seeks to incentivize innovation. And I think this is also something that my international experience taught me. And therefore, IP should work in tandem with other tools that are available out there in order to further various pro-innovation and pro-competition objectives.
That's a great answer. And I just want to say that here at IP Stories, we do our research, of course. And I know you've worked on some major research projects with organizations like WIPO, EPO, and even the European Space Agency. Is there one that really stands out, something that changed or deepened your understanding of how technology and IP law intersect?
That's not an easy one, because a lot of those projects were highly interesting in their own right, and I enjoyed them thoroughly, and hopefully some of them left a useful legacy with these organizations and beyond. But if I have to pick one, I would probably pick the study that I prepared at the time for the European Patent Office. It was my study on inventorship and inventions involving AI activities. I prepared that in 2018, so quite early on our AI a time spectrum. And the nice thing for me there was that when the technology was not in its infancy, but what was in infancy was the legal debate when it comes to IP around it. And there were no lawsuits when it comes to IP. I mean, we have plenty now. And so it was, I wouldn't say theoretical, but what I needed to do on top of providing a sound legal analysis in relation to the legal position on various jurisdictions, in particular the EPO on jurisprudence on inventorship, the concept of inventorship. So the question, one of the key questions was, to what extent AI could be designated as an inventor in a patent application. Now, well, this was a legal question. What I needed to do is, among other things, is to give my predictions on the basis of the existing jurisprudence, the legal position that it existed then. So it was incredibly interesting, and this was done before there was this flurry of applications. For example, in this particular field, all of us that are interested in that field are familiar with the DABUS applications, were filed all over the world. So my study was conducted and actually published before those applications were actually filed. And it was one of those occasions, very satisfying occasions, where as an academic, my analysis and predictions actually proved correct. that it is not possible to designate AI as an inventor, and also my predictions and my analysis in relation to the consequences of what would be the consequences if you choose to do so. I'm happy to say that it is still widely referred to the study in this context. So
Wow, so you were really spot on with the predictions. That's amazing. This is something that perhaps we could even share. If you send us the research, we would be happy to share it because I'm sure a lot of people from our audience would be interested on checking it out. Um, and I've seen that you have also worked with creative industries and major tech players like Microsoft. So, in your view, what are some of the biggest challenges we are facing at the crossroads of IP and emerging technologies right now?
brilliant question, not an easy one, but I will have to choose one, and at the risk of sounding a little bit repetitive, I would say that the biggest, or one of the biggest challenges now, is from the IP perspective, uh, is, is artificial intelligence. Of course, there are other areas, some of which, for example, in the field of life science, gene editing. These are areas that I don't spend a lot of time working on, but it's important to flag them up as important areas. I still believe that it's AI to me, which poses one of the biggest challenges there. So this exponential growth in AI technology, and therefore the ever increasing capabilities of AI systems, um, pose significant challenges to some of the core principles of IP law. Now, particularly in the areas of patents and copyright. However, I do believe that these challenges are not beyond the capacity of these branches of IP law to adapt and evolve. I think it's crucial, though, that we strike the right balance and maintain a holistic perspective of those fields in order to ensure that they remain flexible enough in order to accommodate the advancement in AI technology. So, in short, those branches are equipped and have it within them to accommodate those technological advancements. It would require some flexibility from our side when we apply their standards to certain AI-related contexts.
Yeah, I think that's a great answer, and I would like to follow up on that. The way you were talking about how IP law needs to evolve and adapt and be flexible. So technology has completely transformed how creative works are protected and even monetized. So how do you see the role of IP law evolving, as you were mentioning, to keep up with all these changes?
I think it's such an important question. I mean, I mentioned before that I think that our present legal systems are equipped to respond to these changes that you just referred to, but there must be sufficiently flexible. There must be sufficient flexibility in the manner in which we construe or interpret some of the standards or tests within our IP systems in order to accommodate those new technologies. So, I mean, I can give a particular example from the field of artificial intelligence. Um, eh, eh, if we look at the manner in which we assess whether the work done by an author is 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 original. We looked at a number. We look at a number of parameters, and there are certain questions that we never had to really engage with because we took them for granted. Whichever tool you employed as an author in order to generate output, as long as you had some choice there, we didn't care about it too much. It was original in the sense that it originated from you. There was some choice involved, and that was it. I think that when it comes to AI tools, some of those questions still need to be asked, but we need to be a little bit perhaps more flexible in the way we answer them, taking into account the manner in which these technologies work. So keep a wide perspective always.
So one of the hottest debates in IP is the ownership of works created by AI systems. How do you think the law should adapt to address the rights of creators, developers, and even the AI itself?
Okay, well, that's an excellent follow up from the previous question. So perhaps, yeah, it would enable me to be a little bit more specific as to the adjustments that perhaps needed to be introduced, if at all, and what did I mean by flexibility, to which I was referring earlier, when we do apply our IP law to this new context. So, if we take a work that was created, um, was created. If you notice, I actually paused here. I think that especially as lawyers, we need to be particularly conscious of the terminology that we use, because sometimes the terminology itself suggests or may influence, impact the outcome of the analysis that we purport to conduct. So if I tell you a work created by AI or generated by AI, by that I'm suggesting that it was the AI which is behind the work, and there is no human around, and therefore there can be no authorship, ownership, and the rest of it. So let me be a little bit careful here. When it comes to works, the process of which AI played an important role, a significant role, a crucial role. Pick your choice. I think that we can think about a flexible approach. If we take, for example, the tools that we employed. Now, how do I create how do I create as a human when I'm deploying an AI tool? In relation to a lot of those tools, I would do it by prompts. Okay. Now, if that is what I do, what does that mean as far as copyright law is concerned? Now, we know that the general rule under copyright law is that the author of the work, the author is the creator, right? The author of the work is the first owner, and then afterwards, ownership can be allocated to various modalities. Did that, for example, was the work created in the course of employment, and the rest of it. But that is the default option. Now, when I create work, when I create a work with while deploying an AI tool and I'm using prompts, does that mean that my work should be treated differently under some copyright system? Some systems suggest that may be the case. So first of all, for the purposes of this podcast, I'm simplifying things. But if we look, so we need to keep that in mind, maybe oversimplifying. But if we look at the approach of the US, a copyright office, they appear to suggest that when I'm creating something by using prompts, it is a different process. It is not the same as a traditional work creation process, and therefore, in most circumstances, I may not be considered to be the author. Now, if I'm not the author, that means that I'm not the owner, since the law also tells us that in all jurisdictions that I'm familiar with around the world, that AI cannot be an author. What you have here is an authorless work, so a work without an author, and that means that it's a work without an owner when it comes to copyright law. So as far as copyright law is concerned, you have been engaged, and there are examples out there of artists, and there's a paper trail to show it, that engaged in creation processes with hundreds. So I'm talking about 600, 700, 800 iterations. This is not you sitting in front of the computer and saying, make me A or make me B. You start, and then, as I said before, you use 600, 700, 800 iterations. You prompt the result, and then you prompt it again, and then you prompt it again. one way to look at it, you can say, well, you know what, the prompts are like a brush. Noam is using the prompts in order to create the work, to perfect the work, to polish the work, and therefore it shouldn't be treated differently. The more traditionalist approach would say, well, it is not exactly like a brush, because while Noam has uh, full control over his brush in relation to prompting an AI tool, the control is not full. There is a distinction between instructing a tool, right, like a traditional software tool, and suggesting to a tool. So the argument would be that in the case of a prompt, you can never be 100% as to the outcome, and therefore, rather than instruction, it is more like a suggestion. I think this is where we have this is where a lot of the debate is right now when it comes to the question of authorship, ownership, and my personal take is that under certain circumstances where I engage with the work through prompts in sufficient detail so that I imprint on that work my own personality, choices, tastes, and so on, a copyright law should have the flexibility in order to recognize that as an authorial activity, and therefore, if I'm the author, I'm the owner, and all the rest follows according to our our copyright narrative.
So you spoke a little bit about copyright, but when it comes to patents, AI innovations really seem to challenge traditional ideas, like what counts as inventive or how much of a human element is needed. What is your take on that?
Okay, so I think that when it comes to patents, there are a number of key, highly important questions which are, so to speak, in the process of being answered as we speak. So, just in order to make it perhaps clear to our audience, I think that when it comes to patents, it's important to separate between or distinguish between two completely different contexts, scenarios, and sets of questions. Although both of them involve patents and AI, they're unrelated. One is AI, or artificial intelligence technology, as a patentable subject matter. So this is when you came up with a new advancement or development in AI technology, and you seek to patent it. That is one thing. Highly important, kind of relates to the questions of patentability of computer implemented inventions, but this is not where a lot of the hype is right now. Although, in my view, perhaps it does deserve more than a bit of attention, because it's highly important to the industry. But the second set of questions, or the second scenario, which is unrelated, is something quite different. This is when we are speaking about, or when we are considering innovation in any field, doesn't matter which field, where AI tools were used in the invention making processes. So whether you're inventing, whether it's a new chemical compound, a new drug or pharmaceutical product to treat a certain medical condition, the shape of a new passenger plane, it doesn't matter. Uh, the questions here would be relevant if AI tools were used in the making of the invention. It is here, Fernanda, where those questions that you actually raise are particularly interesting. So the question of I'll pick one because I think that it also relates to something that I work on present. Um, the human element needed. So I said before that in my study I predicted that AI, our patent system, does not allow, and rightly so, for AI to be designated as an inventor. That means that in order to have an invention, we need to have an inventor. It cannot be an AI, and therefore it needs to be a human. But that then gives rise to the following question: what does a human need to show? What kind of a human contribution needs to be established in order for a person to be considered as an inventor. And it is here where we find, at present at least, divergence between national approaches. So without going into the defined details, just flagging it up for our audience, the US Patent and Trademark Office came up with a set of guidelines last February, so February 2024, according to which for a human to be considered as an inventor, he needs or she needs to be behind a significant contribution, and they interpret what significant contribution is within the meaning of patent law and the rules of inventorship. They took a quite different approach to that, which was taken by the German Federal Court of Justice in a very recent decision from June 2024, according to which the human contribution needed is of a somewhat different nature. To use a terminology that the German judges did not use, but I think kind of captures the essence of it, it would be sufficient if the human involved would have an intellectual domination over the process for that person to be considered as an inventor. So even if the real technological leap was completely due to the output of an AI tool, as long as you had some kind of or not some kind, but intellectual domination over the process, you were there, you were directing, you were recognizing the significance and utility of the output, and so on. You, that is the human agent in this process, that may be enough. But it is exactly here where we see those national debates taking place at present, and it is of great importance.
Yeah, I mean, this, we could be talking about this for so long. We might have to invite you to a webinar to explain this further, so we will see. So we have been talking mostly about AI. Also, we are on an AI special of our podcast, so it makes sense. However, I would like to ask you as well, if there are any other technologies or trends you think will create other major challenges for existing IP laws over the next decade.
Right. So, and I'm speaking here. I think I'm driven by personal interest. What I find particularly interesting and is also holding a great potential in terms of promise is quantum computing. I think quantum computing has a potential to transform a large amount of industries. And I understand that as we speak, actually progress and significant progress is being achieved in this field after a certain period of time where it was held mainly as potential. So quantum computing, for example, can be significant. So we talked about AI, example, AI and machine learning. So can really transform AI technology. The ability to calculate solutions and problems simultaneously could speed up training. For example, training of machine learning algorithms, and increase exponentially the capacity of AI systems. So some of the issues that we've discussed throughout this podcast can be exacerbated through the exponential growth in the capabilities of those AI tools. If we look at industries such as chemical engineering, material science, again, quantum computers, their ability to model molecular interactions, subatomic particles, it can transform this technology, this industry, significantly transform it with all the AI implications that could hold. A drug discovery, a drug and chemical research. So quantum computers could create better models to how atoms interact. I mean, the way we actually consider simulation methods could be transformed by quantum computing. And since IP it's about innovation, and since that may transform innovative industries, we can see the potential impact that may have on our IP ecosystem. But again, to my mind at least, this is nothing that the our existing IP system cannot accommodate, subject to the right amount of perhaps flexibility in the right places.
I have to say, I'm really glad that you said quantum computer or quantum technologies, because I'm planning to write an article on that. It's been a while that I'm planning. I have this plan, so I'm glad you said that.
Brilliant.
So, as someone who's educating the next generation of IP professionals, what do you think are the must-have skills or knowledge they'll need to tackle these new evolving challenges?
Oh, that is a question that I keep myself thinking about as someone, exactly as you said, who is educating the next generation of IP professionals. So I'm fortunate enough to educate um, master students and master students and PhD students only. So these are people that already decided that they wish to specialize in IP law rather than in law or commercial law in general. And what I try to convey to them at an early stage of their educational journey is that it's useful to keep a holistic view of IP law. So first of all, we live in a world where a specialization and diving very very deep into quite narrow niches is becoming common, and it has its advantages. But I think that sometimes when we do that, we may run a risk of losing sight of the entire or the important picture. So first of all, it's great if you decide to specialize in patents or in copyright. But to my mind, if a client that comes to you for an advice and you know your copyright inside and out, but that's about it. You don't know much about the rest of it. You may, well, under certain circumstances, your advice may be suboptimal. So I like to look at intellectual property law, and I would like them to look at it as a tapestry of right. And it's not, well, this is the kind of product that I have. What is the relevant right? If you look at a product or a service, technology-based product or service, they have a life cycle, and sometimes a different intellectual property right would be relevant to a different stage or a phase in the product life cycle. So you need to keep a broad perspective in that respect. Now, on top of that, I also think that so part of my holistic view approach is that a good IP lawyer, IP professional should also be sufficiently comfortable and familiar with competition law, antitrust law. You don't have to be the world's expert on that. Some of these platforms or providers that we were referring to before in this particular technological fields hold an incredibly strong position in the marketplace that may amplify their technological achievements. And that may call upon antitrust or competition law questions, and therefore keeping that in mind would be highly desirable in my mind, to my mind, as an IP professional.
Yeah, I think that makes perfect sense. And that could be applied to so many other areas where a specialization or excessive, perhaps, a
Mhm.
specialization can lead to a very narrow view of the issues.
A tunnel vision, as we call it.
Exactly.
Yep.
Yeah. Okay, cool. So I'm afraid we are reaching the end of the interview, but I have one more question for you, Noam. So before we wrap up, I would love to hear about what you're working on at the moment. If there are any projects or initiatives that you would like to share with us.
Yeah, so I'm working on in terms of literary output. So I'm working currently on two books in parallel. Both of them concern AI and IP. I'm writing a paper on the point that I was making, I was referring to before, the different approaches regarding or relating to human contribution. So I gave two examples from Germany, from the US. I'm looking at it from a slightly wider perspective, and perhaps considering a number of other jurisdictions, the different approaches and the impact that that may have to innovation in that field. And lastly, but this I would probably know if in relation to projects in a couple of months' time. I was part of a large consortium that applied for funding regarding AI, the creative industries, but also questions such as employability, economics, and so on. So whether that would materialize, we'll probably know in a couple of months' time. But for now, when it comes to AI and it's an academic project, my hands are full, and I'm super delighted by that. It's an
Yeah,
area
I can tell.
that
Yeah, yeah,
I
yeah.
love.
Really full. And now that I know this, you definitely will have to come back this time for a
With pleasure.
webinar. And yeah, it's been a pleasure, Noam, to have you here today, and thank you so much for sharing all your opinions on so many different subjects. I feel like we have covered a lot, but it was great, and you also put it in a way that I think a lot of people will finally understand.
That's very kind. It's been a pleasure, and thank you both, Marta and Fernanda. I thoroughly enjoyed it.
Thank you so much.
Bye bye.
Bye.
Thank you for listening to IP Stories by 4IP Council. Visit our website on 4ipcouncil.eu to find out more and check out the links mentioned during this episode. If you liked it, remember to share and subscribe.